Hi, I'm attorney Amy Dohrendorf, and I want to speak with you about orders of protection and how they may impact your children and your divorce. Emotions run wild during divorce and child custody cases and often create feelings of uncertainty, helplessness, stress, and heartache. Everyone's reaction to this change is drastically different. People often express emotionally charged feelings towards one another and even expose their children to this behavior. During this time, it is very important to be mindful of warning signs of possible domestic violence from the other party or other family members. In the event of domestic violence, immediately contact your local police or sheriff and report the incident if the opposing party is violent or threatens violence towards you or your children. Then a restraining order is necessary to keep him or her away. An order of protection from the court prevents the opposing party from contacting you and any protected person at home or at work. This form of restraining order is available when there is an act of domestic violence or threat of domestic violence against a family member. If you or your child is a victim of domestic violence, a petition for order of protection should be filed with the court. The petition must state that domestic violence has occurred or may occur. When a domestic violence crime has occurred, then supporting evidence, dates, and testimony about the violent event is necessary for the court to issue the order. If you include your children as protected persons in the petition for the order of protection, and it is granted, the other party will be prohibited from seeing his or her children. Carefully consider this choice, as the court does not look fondly upon gamesmanship or unnecessary interference of the parent-child relationship. It is possible to obtain an order of protection to prevent contact between you and the other party without including your children. Obviously, this does not apply if there are genuine reasons that you fear for the safety of your children. If the opposing party has obtained an order of protection against you, which includes your children, there are several options available to you. The first being that you may immediately request a hearing on the order of protection, and the court must set a hearing within 10 days of your request. The downside of this is that the court may uphold the order of protection, and if so, the court will make a finding that domestic violence occurred. This may later be used against you during your child custody and divorce proceeding. The judge that hears the order of protection matter is not the same judge that is assigned to your divorce or child custody case. At that point, you will have to await the decision of the family law judge in regard to your parenting time. The family court judge can modify the order of protection to fit the needs of the court-ordered parenting time. The second option is through your attorney to negotiate a modification of the order of protection with the other side. More often than not, people obtain orders of protection without consulting their attorneys or prior to hiring their attorney. When this happens, most reasonable attorneys believe that the parent-child relationship should not be hindered absent good cause. If that is the case, it is quite possible to have the order of protection modified or quashed without a hearing. This is an advantage because there will be no finding of domestic violence. The third option is to hold off on requesting a hearing until after the family law matter has been decided. This prevents a finding of domestic violence, which may be beneficial to the long-term outcome of your family law case, but it also means that you may go a period of time without seeing your children. If the order of protection is not resolved through the family law matter, you may then request a hearing to resolve that issue. Orders of protection are absolutely necessary in some situations, but in those that they are not, they can cause unnecessary turmoil and stress for both parties, and most importantly, the children. Not to mention, an order of protection is an escalating factor that does increase attorney fees and cost. You will need to carefully consider your options with your attorney when it comes to obtaining or defending against an order of protection and the collateral damage that goes along with it. Remember, if your safety or the safety of your children is at risk, call the police immediately. If you are in danger, dial 911.